Thanks for tuning in to your one-stop source for the sharpest investment advice on real estate and top industry news and views that you just can't miss. Joining me is Gaurav Pandey, Head of Research and Consulting at Prop Equity. He's the man behind all the solid data on this show. Well, call us if you've got a question, anything to do with buy-sell investing in real estate across the country. Numbers on your screen. Email is property@ndtv.com. All right, let's tell you what's on the show today, and there's a long list. We've got cities that we're going to cover, starting with some best developed micro markets of Gurgaon and Ghaziabad. That's up front. Also on the show, we'll take you to Mumbai and Pune. West India, we'll look at some of the top of the chart homes at hot locations. Prime properties in emerging locations of micro markets of Ahmedabad and Goa. And finally, the big story. If the builders are flouting building norms, what legal options do you have as a buyer? That's a special discussion lined up, and also on what's happening when the developers are not very well known on how much norms can be flouted. Okay, when we come back, legal recourse you have if the builder is openly flouting building norms and not delivering on the promises. This has become so common. We also get you an on-ground report on what's happening across big cities like Mumbai and Delhi. And of course, then we come to a slightly saner city where there aren't too many investors and developers seem to have their act together in a much better way. Home buyers being cheated by builders and developers, missing delivery deadlines, promising much more and delivering something entirely different. These are some of the common emails that we get from the viewers every week and week on week. Oinira Moja, our correspondent, stepped out to get a view on how rampant this practice is, and also found out it's not just the small developers who engage in it, but even the big ones sometimes stand guilty.
Similar cases are happening in other parts of the country, including in Mumbai. These are some of the home buyers who paid for something and got something much different and less in Oberoi Realty's Oberoi Splendor project. If the government fast-tracks the clearance of the real estate regulator bill in Parliament, maybe many home buyers can hope for a better deal. But for now, they have taken legal recourse to get their right.
We have had a shortage of a built-up and carpet area. The construction is contrary to what has been got approved through the BMC plans. The layout has been changed. This project has been sold since 2006, and the layout has been changed multiple times, for which, as per the law, they should be taking approvals of people who have bought the flats, which has not been done.
When contacted, Oberoi Realty sent us this written reply. And their reply says, and I quote, ORL, like most other developers in India, sells flats before receiving completion certificate. There are no legal, regulatory, technical or ethical restrictions in doing so. Also, please note that ORL addresses concerns of its home buyers on a one-to-one basis, unquote. So what does the law offer to such home buyers?
And under MOFA Act, we must file a civil suit, which will cover things like change in plans without approval, conveyance of lands, formation of society, etc. And with the consumer forum coming in the 80s, that has also provided a lot of relief to flat buyers.
Builders harassing home buyers, disputes, litigations, all of these seem to have become a common problem across India. But the question is, who is to be blamed? Is it the builders or the developers, or is it the government authorities? Is it that the government authorities have failed to perform their duties, comply with the timelines, which is why home buyers are having a lot of problems? In Ghaziabad, Oinira Moja Sinha, NDTV.
All right, we're going to get to the bottom of this story with Vinay Singh, our property expert. Many questions to ask. Vinay, thank you very much for joining in. The first thing which I need to understand, Vinay, when Oberoi Realty writes in and says, you know, we don't need to give a completion certificate, we can actually give possession after commencement certificate. Is that correct? If that's correct, then what actually happens? I mean, where is the buyer getting shafted? Is he getting shafted at all, or we are just making too much about it?
No, the problem, Manisha, is genuine. Now, what Realty has said is technically correct. When the flat buyer goes to book a flat in an under construction project, all you should have at that stage, and you need to ensure that it's present, is the IOD, the commencement certificate, and your approved plans. Now, building will take a lot of time to get completed, maybe a few years. Once it is ready, only then will your occupancy certificate come, and only thereafter will your completion certificate come. So it's okay to sell while those two documents are not there, obviously, because the building is still coming up. That is not the issue. The issue is that once the builder has committed to delivering in a particular time frame and he does not deliver, he has already built in safeguards in the agreement. Shortage of labor is a force majeure clause for him, so if there is no labor according to him, he does not have to deliver on time. Shortage of material is a force majeure clause for him. So if there is shortage of material, even sand or stone, he doesn't deliver on time. Now, these are the issues that need to be addressed. When we are signing an agreement with the builder, we say, listen, I don't give a damn whether there was a labor shortage or whether there was a shortage of material. You give me a committed time frame and you compensate me if you go out of that time frame. This is how the agreement should be structured, which unfortunately it is not. So that is becoming one real serious problem. The other problem that we are seeing is that no builder is allowed to give you possession until and unless you have received the occupancy certificate. Whereas today we are seeing that even big builders like Lodha in the city of Mumbai are writing letters to you saying your flat is ready for fit out, where the occupancy certificate is not yet in place, and they are requesting you to take possession. If you fail to take possession, we will start levying charges, as one of the callers said, 100 rupees a square foot or whatever it may be. Now this is completely illegal. He cannot offer you possession unless the occupancy certificate is there in place, and you are legally not supposed to take possession and occupy that place until that occupancy certificate is there. So how are these builders asking you to pay money? One fails to understand.
But Vinay, what's the way out? I mean, you know, even the largest of developers, and we're taking some of the names, these are the big developers of Mumbai, and this is happening blatantly all across the country. You are not supposed to allow people to actually come and live in that house till you have the occupation certificate. Without that, you are telling them, come occupy. So the owners of everything from connections to any mishap happening is a big question mark. How do you stop it?
It's the only way you can stop it is that your agreement should be strong. I mean, in one of the cases in Mumbai a couple of years back, I think it was in Kalyan if I'm not mistaken, the builder had agreed to pay a daily compensation for each day of delay. And because it was there in the agreement, the flat buyer was able to go to court. He won the case and he got a thumping amount in compensation. I think it was almost to the tune of about 33 lakhs if I'm not mistaken. So the whole problem starts with the document itself. If we make an agreement and we insist that until and unless you let my lawyer get involved and I negotiate with you on the agreement and I have these safeguards built in, I am not going to sign the agreement. This is the first step that every flat buyer should take, and he should be prepared that if the builder refuses, you get up and walk out. That much courage one should have. When enough people start walking out, the developers will be forced to listen to you, they will be forced to negotiate the agreement with you, and that is what is going to ultimately be your safeguard. Nothing else can safeguard you.
Vinay, I'm so glad that you've highlighted exactly what the crux of the problem is. You have to, every buyer has to go through the buyer-seller agreement, probably take legal advice and make sure he includes clauses which are stacked in his favor, because otherwise even a legal recourse later on is not possible. On that note, let's bring in our next caller.